going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. Happy Friday. Yay. Made it. We made it to the end of another work week. Hopefully you guys had a great week and you have some great weekend plans. That being said, you want to watch some court? I want to watch some court. Let's watch some court. All right, what do I have tonight? We've got a bunch of pro ses, a bunch of them. Yeah, we're going to be bouncing around to a bunch of different courts. Yeah, I know there's one judge that has two, but then we're bouncing around. I think we're starting with this. You know what? I don't know what order I put these in. I don't remember. Anyways, there's one in particular that is so close to being a sovereign citizen. I was watching it and I'm like, oh, he's gonna drop it. He's gonna drop a line. He's gonna do it. He's gonna do it, and then he never did. I think you're gonna know which one I'm talking about. Then the other ones are just, they're just skirting the line a little bit. Anyways, we're gonna have a fun night. Hopefully, you guys enjoy the video as much as I did putting it together. All right. Yeah, that's really all I've got for an intro. So let's do it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Calling case number 25020-304, Foster versus the Secretary of State.
Good morning, Your Honor. David Cannon, Assistant Attorney General on behalf of the Secretary of State.
Right off the bat, Shane, with the anniversary, that means instant pause. Thank you so much for the 2 years, Shane. That is awesome. Congratulations. Thank you. Thank you so much. 2 years. Man, let's go.
State.
David Cannon. Wow.
There's one that's
there's a fossil, huh? David Cannon. Wait till I tell my wife I saw David Cannon today. She'll be so excited. She's one of your biggest. She's one of your biggest fans, Mr. Cannon. You know my wife, right?
Yes, I do. Yeah.
Well, good to see you. Good to see you.
Good to see you.
Anyone else here? Who's here? Who's here? Who's the petitioner?
So, Mr. Foster is on here somewhere. He's representing himself.
Mr. Foster?
Yes,
are you here, Mr.
Honor.
Foster? Good morning, Mr. Foster. How are you, sir?
Very well, sir. Yourself?
Good. I've known Mr. Cannon a long time. I haven't seen him in many years, so I was just going down memory lane with him. What do we got here today, Dave?
So, Mr. Foster has filed a claim as to his driver's license, a sanction on his driver's license. Unfortunately, I don't know what that sanction is or have any response on the merits for the court. He didn't serve the Secretary of State, and his his name, like mine, is fairly common, and so we can't pull up his driving record.
Yeah, this is absolutely the same judge from the video earlier. He was the judge that I played towards the end of the video. One with the attorney that was having fun. I don't think we're gonna see that. I don't have that in here. Yeah. Anyways, good to see you.
We essentially have nothing to present to this court because there was no service on the Secretary of State.
So, Mr. Foster, let me ask you a question. Did you think about maybe getting a lawyer that could help you, or do you want to do this on your own? Because I don't know your background. I don't know if you have any legal training, but obviously I can't do anything today based on the statements made by Mr. Cannon. So it sounds like maybe you could be eligible at some point, but without proper notice, the Secretary of State can't respond yet. So just want to know if you have any thoughts about maybe getting a lawyer, talking to a lawyer, or if you still want to represent yourself.
Yes, sir. I absolutely have considered getting a lawyer. The problem has been throughout the years, most lawyers aren't familiar with Secretary of State issues and these type of appeals. B, they are very costly, as starting at least $10,000 and up. I petitioned VJO, so I do have federal government. As a veteran, I have asked them to weigh in and provide some legal services. I'm waiting on a response from the federal government. Went out to private lawyers as well. And I
What
would
about
like
what
to,
about free legal aid? Don't they have free legal aid?
yeah, so I have contacted the Free Legal Aid, and as I've stated, they all have stated that they are not familiar with Secretary of State actions, and these are not actions that they want to take on.
Okay.
And so if you look, this case is over 20 years old. And so this is not a new issue as far as getting representation uh, to mitigate this
Well,
these
I can't do anything today. You have to have proper service, and I can't tell you how to practice law. That's the problem. I'm handcuffed. I can't, as much as I want to help you, I can't give you legal advice. I'm just trying to help you in a roundabout way. That's all. Trying to.
right.
So
And so I'm not sure at this point because these are civil rights issues, which gives
Ham is one of my absolute most favorite thing on the planet. Ham is always okay. You're good.
this court's jurisdiction at any point in time to
all right. Well,
render decision.
Mr. Foster, I don't know what you're talking about. With all due
Right. And so,
respect, you
yes, sir.
you have a matter. You're trying to get your driver's license back. That's what's before me today. That's it. That's all
Yeah,
we're dealing with today. Nothing about civil rights.
that's
It's
the
not in front,
defense
Mr.
on the
Foster.
motion,
Mr.
sir.
Foster,
Yes, sir.
you got to listen to me.
Yes,
I
sir.
want to help you, but this is not about civil rights. This is about getting your driver's license back. That's it. Why was it taken away? Do we know, Mr. Cannon? Anything?
No, unfortunately, I really can't help the court.
See,
He
Mr. Foster,
mentions-
Mr. Cannon has been doing this a long time. He's actually got a heart. He's a good guy. If you can get your license back and you follow the rules as far as paperwork and things, he's not going to work against you. He has a job to do, and he works for the state of Michigan, but he's not against you. He's not about here to say, Judge, don't give this to him. You just have to serve them properly, the state, and you didn't. So I don't know
I did.
what.
I served them, Your Honor. And so the idea that they said I didn't, I've sent certified mail to them with service and proof of service of these motions that's here. And then I also filed in the electronic service system down there. And then also, more importantly, the reason why this gentleman can't find anything is because they petitioned it in a name that is not recognized by the Secretary of State. My name is Ronald J. Foster Jr. Their whole petition and bringing an order to me was improper in the first place. It is a common name. And so the idea that they bring an appeal, an order in Ronald Foster, when the original case is in Ronald J. Foster Jr., shows that it's an administrative issue on the Secretary of State's part and began. And so for me to respond to a petition and then ask them to serve a petition, I think the burden is on the Secretary of State to identify who it is that they put an order on. I've never changed my name, but this indictment in case I've not changed in 20 years. So the fact that when I went to Duane County, they rejected every motion that I had and had me to exclude my middle name and my suffix name to bend over for the Secretary of State. And so the burden is on the Secretary of State to identify who did they put this order on. And that's where I think the issue is. The burden is not on me to defend a name or unrecognized identification under the Secretary of State under Michigan in this indictment, in this claim, and in this order. The burden is on the state of Michigan and the clerk's office to identify who it is that they indicted on this order. It's not on me to defend who I am. My identification is clear. The original case is clear.
You have 2 more minutes, Mr. Foster, because I have dinner plans. Go ahead. Keep going.
Judge. You have 2 more minutes. I have dinner plans. Now, this guy isn't a sovcit. No one in my video tonight is a sovcit. I said that in the intro for anyone coming in late. We just have a lot of pro se defendants or a few, I'm not going to say a lot. I only have like 4 clips. We have a few pro se defendants that are really close to that line. And this guy's angry because apparently they suspended his license, or they put a sanction on his license 20 years ago, and he's saying it wasn't him. So that's why he's frustrated. He can't get any answers. That would be frustrating, especially if you wait 20 years to deal with it. So yeah.
On.
Oh, no,
You're
sir. No,
arguing
sir.
everything to me. I have no idea where you're coming
Right.
from. I'm trying to help you, but I don't know what you're talking about. Burden of proof. I don't know what you're
Right. So
talking
my
about.
name is
Mr.
Ronald J.
Cannon,
Foster
stop talking,
Jr.
please, sir.
Yes,
Mr.
sir.
Cannon, can you try to help Mr. Foster? What's he talking about? I don't understand.
Well, I can
mean,
tell
maybe
from what
this
you
is your
said.
bailiwick. This is what you do. Tell me how we can
Right.
help Mr. Foster and what he's talking about, because he seems very frustrated with the system, and I don't blame him. Obviously, he's here, he's polite, he's respectful, but he's frustrated, and I want to know if we can help
Right.
him in some way. It
So
seems
this
like
is
it
what
can't be
I'll
that
do, Your Honor.
complicated to at least let him have his hearing.
Right. So, of course, the Secretary of State doesn't have anything, and I can tell that his comments are all about working with Wayne County in terms of e-filing and petitioning and that type of thing. And so he hasn't said anything about service on the Secretary of State. So they appropriately don't know who he is. I don't know who he is, but I will take it upon myself. I won't do this in lieu of service. He still has to eventually serve the Secretary of State, but to get the case started, if he wants to email me his petition and his driver's license number. If I had a driving record, Your Honor knows I know these cases up and down more than anybody wants to. And if I had his driver's license in front of me, I could
What
could
is your
guide.
what do you have Mr. Cannon's
So,
email, Mr. Foster?
No, sir.
David, can you give him
all
your
right, I can
email?
give it right here on the record because it's such an old dog. It's easy to go. Canon D. Canon D. Michigan.gov. It's so old that it doesn't have any numbers or anything after it. It's Canon D.
All right.
Well,
So
I appreciate it, Your
Mr.
Honor.
Foster, you heard what he said. He made a generous offer. Send him your copy of, what do you want? You want a copy of his driver's license and his driving record?
Right. Something that gives me at least his driver's
And
license
he
number,
will,
Your Honor.
this is an extraordinary effort by the state of Michigan. Take advantage of it, Mr.
appreciate it.
Foster. Well, you're
I
a nice
appreciate
guy. You're trying, and you were frustrated. I can't give you legal advice. Mr. Cannon wants to be fair. He feels that if you're entitled to get your driver's license back, and it's just a technical issue on service, he's going to try to help you. If you're not he's not agreeing to give your license back, but at least you'll be in the game, so to speak. Okay. All right. We're good to go then. We're going to dismiss the motion without prejudice today. And
Okay, Your Honor. Now, if I learn that he's revoked and he has to go back, which is I'm suspecting is the case if he says it's 20 years old, he's probably been revoked for decades, and then he would have to go to administrative hearing. So I want him to know that if that's my answer,
you can tell him whatever you want to tell him.
Your
He's going to
Honor.
send you the documents. Yes,
Your Honor,
Mr. Foster.
Your Honor,
Yes.
may I just, I'm sorry, I didn't, honestly.
Mr. Foster, just tell me what you need. I got a lot of people
I
here
would
that
like
need
it,
me.
I would like an adjournment to get legal
You
representation.
are getting an adjournment. I'm dismissing your motion
Okay.
without prejudice. You can renew it
Okay.
anytime you want. It's just that it's not going today. Okay. All right. Thank
Yes,
you.
sir. Thank you.
Thank you. Thank you both.
Yeah.
thank you, Your
Thank
Honor.
you. Pleasure to see you, Dave. Okay.
Pleasure to see you again.
Yep.
All right. You are getting an adjournment. I'm dismissing your case without prejudice. That's one way to look at it. I mean, that's kind of technically an adjournment if you choose to refile. So that's kind of funny. Haven't heard it that way before. Anyways, that was fun. I'm pretty sure we're staying in the same court for number 2. Let's see. Oh, hold on. Yep, same court. I've been really enjoying watching this judge. He's a retired judge. He's taking the bench for someone who's on sick leave right now. Oh, they're supposed to be back within the next couple weeks, so we're not going to get too much more of him. But yeah, I really do enjoy him. Rick, thank you so much for the 10 months. I appreciate it. Thank you.
Calling case number 22014-545, Public Service Credit Union versus N Yang.
Good morning, Your Honor. Stephen DeLuca on behalf of the plaintiff.
Okay. All right. What are we doing?
Your Honor, this is defendant's motion to set aside default judgment. I believe defendant is here.
Okay. Where's plaintiff?
Good morning, Your Honor. I'm
plaintiff, Your
You're
Honor.
plaintiff. You had a default judgment against.
Yes. Good morning, Your Honor. It's Charles.
Hang on. Stop. Hang on a second, Steve. This is your motion.
No, Your Honor. This
Right.
is the defendant's motion.
Okay. All right, Mr. Inyang, is it, sir? Sir. Okay.
Yes, Your Honor. I'm attempting to take it off mute. My apologies. Good morning, Your Honor.
Can I see your face, please? There we go. Okay. Don't touch any buttons right now.
Okay, there it is.
Okay. All right.
Okay. Good morning.
This is your motion, sir?
Yes, Your Honor.
Okay. Go ahead.
Good morning, Your Honor. Charles Yang, defendant, appearing in person, pro se.
Okay. What's your motion?
Thank you, Your Honor. This motion
I'm appearing in person, pro se. You're not in person. No, you're not. You're on Zoom. That's not in person. Okay, this is gonna be good.
should be granted because
What motion is it that you want granted, sir?
to remove default judgment.
Okay.
Okay.
All right. What, Mr. DeLuca, are you in agreement?
No, Your Honor.
Okay. Well, go ahead, Mr. Inyang. Why should I set aside the default?
This motion should be granted because the default judgment is void for lack of personal service under MCR 2.105, meaning the court never obtained jurisdiction. In addition, my affidavit set forth multiple meritorious requests. The court set aside the default so the case can be decided on its merits.
Can you use merit twice in one sentence? He just did. I don't know how I feel about that. Is that correct? I mean, who am I to judge someone's grammar? Last time I did, I was absolutely crushed because I was wrong when correcting. So, yeah, a grammar school said yes. There we go.
Mr. DeLuca, when was this default taken?
The default was entered on February 17th, 2023, and the default judgment was entered, it looks like, in April 2023. I can give you the exact date, but quite some time ago.
Okay. So what have you done with that default? Have you taken any action?
Yes, Your Honor. And June 6, 2023, this is a claim and delivery case, I should say. June 6, 2023, Court Officer John Henry Davis executed an order to seize property and took possession of the subject vehicle at the time. And court officer seized that vehicle, took possession of it. Defendant was well aware of it and present at the scene. That vehicle was seized under Judge Frazard's order to seize property that was issued on May 30th, 2023.
Was she the judge that issued the default?
No, actually, was a different judge issued the default.
Mm-hmm.
I think it was, I want to say it's Judge Lither, but I can double check.
What year was that? 23?
2023.
Mm-hmm. So, Mr. Inyang, why are you filing this now, years later? What's the reason there was such a delay?
I was never properly served with the summons and complaint as required by MCR 2.105. Where the case after default was already.
Well, I guess, Mr. DeLuca, if he says he wasn't served, and I'm sure you're going to say he was served, maybe this is going to require an evidentiary hearing. If he wasn't properly served, it's an issue, right? I mean, that would be an issue. Although
possibly, but first I would say that the whole point to service is achieving actual notice of the proceedings. And we have a ton of evidence that defendant actually knew about the proceedings very early on and did nothing. I've attached to my response where defendant shortly after back in 2023, defendant filed a complaint with, I believe, the Attorney General's office against my client. And in that complaint, he admits that he knew about the lawsuit. So he's had actual notice of these proceedings for a long time. And we've mailed to him 5, 6, maybe 7 pieces of mail. He missed 2 court hearings before the judgment was entered. He just, I have every indication that defendant had actual knowledge of the proceedings and just chose to ignore them. So I don't.
Mr. Inyang, is what counsel is saying incorrect?
Yes, Your Honor.
Is that all? This is the first time you've ever seen anything on this file? How did you even know to be here?
Your Honor, I came aware of it after the repossession, and I filed a claim, and I was not served, Your Honor. Knowledge of this, I was not properly served under 2.
Well, I know you keep saying that.
Yeah, but I never received personal service. I did receive something after I looked at the.
Were you present for any of these events? He said you've been present for these events. Were you present when your car was taken?
Yes, Your Honor, I was. That's when I became aware of the proceedings.
And how long ago was that?
That was, I believe, 23.
23, and so it's now 26.
Yes, I had to do my research, Your Honor. I had to go.
You had to do your research.
Yes, Your Honor, because.
Okay, so you were made aware of this back in 23 at the latest, correct?
And the first time I was aware of it was during the repossession, the actual repossession.
Okay. What did you do about that? Did you contact anybody?
I did contact the Attorney General of what the defense counsel was stating, and it was not to show notification of any servicing. It was more for the complaint. After I contacted the Attorney General, I did further research, and that's when I found out that the procedure was not. I was not properly served.
Okay, all right. I'm gonna grant your motion as prayed for, Mr. DeLuca. Obviously, Mr.
Yeah, he did a lot of research. I mean, so much that he had ChatGPT write his opening statement. This is good. Real quick, since we still have a few minutes left of this one, Phil, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much, Phil. Also with the 26 months. Boy, do I feel old. 26 months. You're one of the oldest on the channel. Well, membership wise, not age wise. I had no idea the answer to that question. But thank you so much for the 26 months. And nope, already got Rick's. All right, let's go.
Inyang, if you want to appeal the decision, you're more than welcome to. But I think the paperwork is in order. It's clear from the record that even though you say you weren't properly served, even in your best argument, you were made well aware of this in 2023. And I just don't think anything you're doing at this point is timely at best. So I'm going to respectfully grant the motion for Mr. DeLuca.
Your Honor, thank you, Your Honor, but just for clarification, this is
I guess deny the motion as to Mr. Inyang. Obviously, there is no motion for Mr. DeLuca. I'm going to deny your motion without prejudice, Mr. Inyang. If you want to renew it and you have different facts or different evidence for the court, certainly I think the circuit court judge, whether it's me or Judge Lillard, would probably
Yes,
I think.
You frozen.
Yeah, it froze on my end too.
Oh, how you doing today?
Not bad. Well, we'll see what happens here, but I think the court's made its ruling, but I'll wait here a little bit longer to see if we get him froze here.
I'll wait as well.
Okay. Ready to go.
Oh,
Okay.
sorry about that. Yeah, it looks like you had froze on our end.
Yeah, I didn't hear anything at all, Your Honor. We have to start over.
Well, I'm sorry. Mr. DeLuca, did you hear my ruling?
Oh, I did. I didn't say we have to start over. That was
Okay,
Mr.
all right.
Inyang.
Mr. Inyang, I've made a ruling. I'm respectfully denying your motion. And like I said, you didn't hear that part? Is that what you-
I did hear the last part where you denied my ruling.
Yep. Okay, then then we're done, and you can appeal it if you want, sir. Okay.
Okay, well, I guess you've made your ruling. Thank you, Your Honor.
Thank you, sir.
Thank you.
Yep.
Calling case number 25.
Wow. Wow. He actually stopped talking, you know? Oh, you made your ruling. Okay. I'll respect that. Oh, that doesn't happen that often with the pro se. Felix, thank you so much for the 2 months. I appreciate it. Rusty LaFleur's sibling is Virginia LaFleur. Okay. Thanks, Felix, for the 2 months. I appreciate it. All right. Let's just keep going. Let's just keep going. I think the next one is
The next
Oh yeah. Yeah, this might be the best clip of the evening. It's good.
case on our calendar is 39344, Carrie Peterson versus Expedia Group. It looks like the parties entered into mediation and that did not succeed, and the parties are requesting to go to trial. Mr. Peterson, I see you're with us on Zoom. If you could turn on your camera and unmute. Good morning, sir. How are you?
I'm doing as much as the Almighty allow me to do. How about yourself?
Good morning, and Ms. Abreu, good morning.
Good
Can
morning.
you both hear me okay?
Yes.
Okay, so what's going to happen is we're going to have a trial, a small claims trial, and the court will hear from both parties. What tends to happen in these proceedings is that one side will get upset about what the other side says, and that's understandable. But even if that happens, the court orders you to not interrupt. Everyone will have a chance to be heard. Mr. Peterson, I see you raising your hand. Did you have a question?
Your Honor, correct me if I'm wrong. As of in the month of, I think around or about, about December 22nd, I believe there was an appeal filed to the Superior Court.
Are you saying you filed an appeal to the Superior Court?
I believe that's on the docket as we speak. Yes, sir. Yes, Your Honor.
Okay, well, if you've filed an appeal to the Superior Court, you're certainly welcome to do that, but there's no stay of this proceeding that's resulted from that appeal, so we're going to go forward.
Well, we're at the stay today, right? That's what happened. There was a sua sponte stay because there was an absentia in the last trial. Am I incorrect?
Let me just double check the docket. I didn't see any stay in place right now.
Will continue stay. I mean, obviously you guys stayed the default judgment. The respondent was a no-show.
Oh, I understand what you're saying. So there was a continuance that was carried over to set the trial for today. That's not a stay of the proceedings. So this court has authority to proceed forward on a trial.
Your Honor,
are you saying you're not ready for trial?
No, no, Your Honor, I'm not saying that at all. I'm saying exactly what I mean. I filed a what they call interlocutory appeal because there was a continuance order issued sua sponte due to an absentia. Okay.
No,
and
I saw that.
I had consultation to what your state law, your statute reads when the defendant's a no-show, it's a default judgment. I mean, you don't have the power to
yeah, so I'm not going to relitigate that argument right now. I saw that there was a continuance. I saw that there was a continuance. I saw there was an objection to the continuance. If you've filed an appeal, of course, you're welcome to do so, but that doesn't stay these proceedings, which means we can go forward with the trial now, unless you're requesting a continuance, in which case the court would consider that.
But if I file the appeal, you guys will lose jurisdiction, isn't that right? That's what the Supreme Court says. They wrote a letter back to me with respect to this case matter as well.
At the same time, so it makes it very hard for me to understand what you're saying. So and also your microphone is a little bit tinny, so it's hard for me to understand you. So after I stop talking, if you can just tell me, do you want to proceed today or do you want a continuance because of that appeal?
Can you hear me now? I'm taking off my Bluetooth.
That's much better. Thank you.
Okay, I apologize. It's the technology. The building that I'm in is the signals are very difficult. I filed the interlocutory appeal back in December. We did not meet any type of stipulation in mediation. I'm familiar with the respondent's practice out where I reside at, actually in California. She's involved or was involved in a federal case. And the same modus operandi was applied in that case, kicking the can down the road and playing with the courts. So, yeah, I don't want to go to trial. I filed for the appeal with the Superior Court. The Supreme Court had issued a letter because I had went through the chain of command after your court, the Inferior Court, had filed the Superior Court appeal erroneously to your docket. Then in turn, I went to Division 2. Division 2 said, we don't handle this matter, go to the Supreme Court. I went to the Supreme Court. That's why I see the letter. That's the last thing docketed from my understanding, what I can see on your court docket. But yeah, I mean, this case had already been beyond the jurisdiction of your court after that no-show was there, because from my understanding, your RCW states for default judgments that if the defendant's a no-show within an hour and they don't get back to the court, it's automatically a default judgment. I mean, the judge, I've got the audio or whatever, the video from that recording, that hearing, he gave default judgments for other respondents that were absentia. I'm not sure why I didn't receive the same justice.
So I'm sorry, Mr. Peterson, if I could cut you off. What you've said raised a couple issues for me. Number one is, do you want to proceed with trial today, or do you want to wait and see what happens with your appeal?
I can. I filed an appeal. You guys, your clerk docketed a Superior Court or a higher court record onto your docket erroneously. They didn't send it over to the higher court in turn to, correct that particular error.
I'm sorry to interrupt
I
again.
don't want to try.
Peterson,
I did want one back in September or December, whenever this happened.
Mr. Peterson, if you could stop talking for just a minute. I'm not asking for a long explanation as to why. I'm merely asking, do you want to proceed with trial today, or do you want a continuance so you can pursue your appeal?
No, I want to.
Oh my gosh. 4 times he asked a question before he got an answer. Man, this guy's aggravated. One of my biggest pet peeves is when, the defendant, well, he's the plaintiff. When someone's interrupting the judge and the judge calls them out on that, and it's like, oh yeah, you can't do that. Don't interrupt me. You can't talk while I'm talking. And then so the judge keeps, or re-asks the question, whatever he was waiting on the answer for. But then the other person who just got kind of yelled at says, I'm sorry, in the middle of that sentence. Like, come on. It happens almost every time. It's funny, but frustrating at the same time.
Adhere to the jurisdiction that's respective right now based on what I filed back in December.
Okay, so I'm not asking for a long explanation. What I'm asking for is, do you want to proceed with trial today?
Again, I'm saying no.
Okay,
this hearing has no jurisdiction at this point based on what I filed and what the state law is.
I understand that's not before me right now. So you're saying, no, I don't want to proceed with trial today, which means, are you asking for a continuance?
I am not asking for a continuance. I am asking for the appeal that I filed back in December. Your Honor, are you familiar with the record?
I've reviewed the record. What I would like to know is, would you like a continuance today so that this trial can proceed in the future, or not?
No, this hearing doesn't have jurisdiction at this point.
I understand. If you don't want a continuance, then the court will proceed with the trial today.
But I already filed the appeal previously, so we can't do a trial. The trial would be at this. You're not the Superior Court, right?
The appeal does not stay these proceedings.
Okay.
You can ask the Superior Court to stay these proceedings, but it does not automatically stay these proceedings.
You would be correct to the effect, sir. And I thank you for you're right, because I did the interlocutor for the sua sponte continuance order. That's correct. We can go to trial if it's going to have an impartial hearing, but I mean, I'm at work right now, and I think I explained to you guys in all the filings and showed proof of what I do for work. I didn't even get a choice when I get, the prior judge had asked, when other plaintiffs or parties were available. He just scheduled it and didn't ask. And, that's very considerate, but Yeah, I have a job, even though there's a federal shutdown going on. I'm a few years from retirement, so I got to hit post every day. I can't just go home.
I understand, Mr. Peterson. So, Mr. Peterson, there's one other issue I want to raise before we keep going forward with either continuing or going forward with the trial, which is you'd mentioned that you had appealed and that it went to the Supreme Court, and you mentioned Division 2. I just want to put on the record so you know that I'm sitting here today as a pro tem judge. My normal everyday job is as a commissioner at Division 2 Court of Appeals. I don't recall seeing anything come across my desk from you. It probably went to a case manager or another commissioner, but there's a chance I've seen some kind of file of yours pass through there. With that said, do you have any objection to my acting as a pro tem in this matter, or would you prefer a different pro tem judge hear it?
I think it's a conflict of interest due to the fact that your senior case manager was the one who told me that they couldn't be bothered with it and to file it with the Supreme Court. So I believe that's a conflicting issue. Thank you for addressing that.
Okay, so you would object to my going forward with it?
I believe so, because your coworker is the one who told me to file it with Supreme Court, and you saw Supreme Court's response was, we don't have a particular interest in this, and you don't have jurisdiction at this point. You have to go through the chain of command to the Superior Court. That's where your writ would be filed. And this was just information. Again, I mean, I filed the emails from your senior case manager.
I appreciate it. I'm just trying to limit the questions to one thing at a time. Ms. Abreu, do you have any objections to a continuance so that this can be in front of another pro tem judge so there's no questions about a conflict of interest?
Yes, Your Honor, I do, and I don't believe there's a conflict of interest. The reason why we're here today is because on December 19th, on the day of the hearing, requested a continuance because we were not served correctly with the actual court date, and 2, I was in California for a different hearing, so I couldn't be here. The court granted my continuance. There was no default or there was no-show, and he filed an appeal to the Superior Court when this case has not been litigated. There is no appeal to be filed, so that was wrong on his.
I was gonna ask that. I was so confused. How did he file an appeal already when when this is the day of trial? I was so confused of how that was going to work. I'm so glad the attorney is actually making sense here. The judge is just trying to get answers to his question. The plaintiff is confusing everyone. I'm glad the attorney's paying attention.
And then he went up to the appeals court, and they basically said the same thing because there is no writ to be handled because this case has not been litigated. There was no-show, there was no default. The court simply granted my request for continuance, which is not unusual in a small claims case, again, because I couldn't be there due to other commitments. So I do object to his now motion because of a conflict of interest. I don't think there is one. There is no appeal pending in the appeals court at the moment. And I haven't heard from the Superior Court either. So I do object, Your Honor, respectfully.
Okay, I understand. Thank you. Mr. Peterson, just so we're clear, you're saying that you would prefer I not handle it. Obviously, I'm the judge that's sitting in small claims court today. So would you be asking for a continuance to a future date with a different pro tem judge?
I believe that I'm asking for the entire case, the proceedings to be set aside, because I believe that the prior issue needs to be cleared before there's any trial, that this thing is escalated. And the fact that you are a commissioner for the Division 2 appellate court, and the fact that the senior case manager was the one who told me specifically, and this is filed in the record. So you've got the copy of the email. All right. And they told me to go to the Supreme Court. So, I mean, that information, that's a, clerk error, but that's what brings us today. And, I am familiar with the case that the defendant's talking about. I'm familiar with the record, again, same modus operandi of the situation at hand. So I don't give any grace or anything
Mr.
like
Peterson,
that.
When I start talking, that's where you stop talking, not because of anything with me personally, but just out of respect for the court. In order to avoid any complications, I don't think there's any actual conflict of interest here, but to avoid an appearance of a conflict of interest, I'm going to recuse myself from this matter, and we're going to therefore have to go ahead and do a continuance. And this matter will be set to
Our next date would be May 8th.
May 8th at 9 a.m. And the parties will be required to appear on May 8th at 9 a.m. A remote appearance on Zoom is fine. And so this will be set aside until then, and the parties are both excused for now. Thank you.
Thank you.
Thank you, Anna.
Yeah, Alan, we have no idea what that case is about. We didn't hear anything about the case. Just verbal nonsense for 15 minutes. That was the guy who, in my intro, I said there's one of these defendants is really close to being a sovereign citizen. That was the one I was referring to. But I don't know. The guy from the first clip was pretty close as well. And yeah. All right. I think that's it for the pro ses. What do I have next?
This is
I don't remember this one. I don't remember this one at all. Yeah, so let's go.
case number 25.
Oh wait, hold on. I got a super chat real quick. Sorry, my phone is not on silent. I apologize, guys. Wixom, thank you so much for the super chat. I appreciate it. Bill told me I better bring cookies this evening, given my John Lindy live stream kerfuffle yesterday. I appreciate it. I appreciate it. And I saw you in court today. I saw you there with Bob. And was that Bob's wife? I don't remember if that was his wife or his friend. I don't remember, and I don't want to be wrong. So I'm just gonna say I saw you and Bob. That's the best way to do it. And yeah, took a plea deal. Yep, he took a plea deal. So today was just eh. So that's kind of annoying that you were there all day too for a plea deal. Anyways, thank you. Appreciate it. Let's go.
5017-515-CZ, Hunter Harding.
Yes, my birthday is in 3 weeks from today. Yes, 3 weeks from today. Hopefully we'll hit 25,000 subscribers by then. So if you're watching and you're not subscribed, maybe go ahead and hit that subscribe button. I think I'm under 450 subscribers to 25,000. So it's a little bit more than 400. I think we can do it. We got this.
Et al. Versus Travell Judon et al.
Morning, counsel.
Good morning, Your Honor. Patrick Foley, P number 74323, appearing on behalf of the plaintiffs and moving party.
Ms. Clinton, did you indicate that the defendant is here? We'll let the defendant in and we'll just make a record, Mr. Foley.
Thank you, Your Honor.
Would you state your name, sir?
I am Travell Judon.
Thank you. Mr. Foley, you may proceed, make a record.
Thank you, Your Honor. We filed a motion. The complaint in this case was served. Pardon me. I don't, of course, have my notes in front of me, which I just did. The complaint in this case was filed on November 5th, 2025. Mr. Travell Judon, the defendant, and his company, via service of him, was served on December 3rd, 2025, individually in person at the address at which we know he resides at approximately 7 p.m. No answer or response was filed to the complaint. Defaults were entered on January 5th, 2026. They were also mailed to the defendants on January 13th of 2026. And we have now brought before the court a motion to enter default judgment. Our default request is very reasonable. It does not contain treble damages. It simply asks for the amount that is owed, plus the interest that has been being charged. Originally, they were charging something like 10% interest in the form of penalties every week. I explained to them that that's not going to be passable. We cut it down to 10% annual interest. Mr. Judon began calling my office, I believe, 2 weeks ago, trying to argue that he had not received, that the service was fraudulent or something like that. It is respectfully, Your Honor, nonsense. I have text messages, which I can provide to the court in PDF form from one of the plaintiffs, where Mr. Judon texted him immediately after receiving the complaint, citing allegations within the complaint and stating that he believed they were wrong. And also stating, though, that he understands why he's being sued because he hasn't paid and he knows that he owes the money. So there's been no motion to set aside the clerk's default filed. To the extent that Mr. Juden decides that he wants to challenge here on the record this court's right to enter this default, I think that can be handled with 2 easy questions.
Wixom, I don't even want to make a real long comment about that. Is it possible? Yes. There are services that do that, but they send bots to your channel, and YouTube massively frowns upon that. You can get in a lot of trouble for that. So let's not bring that up again.
Which are, did you actually receive the complaint and in fact text the plaintiff or plaintiffs about it? And 2, do you admit that you owe the money? Because he has no meritorious defense. He hasn't put forth any affidavit of meritorious defense. And his appearance today is the last-ditch effort to avoid entry of judgment and frustrate a process that has to date taken us 5 months. And, you know, there was a bunch of time that elapsed before that, during which time my clients were reaching out, trying in good faith to negotiate and have them agree to pay, and nothing. So we ask the court, please, to enter the default judgment so that we can begin collection. Thank you, Your Honor.
Thank you. What did you want to add, Mr. June?
On my behalf, and what I was trying to speak to Mr. Foley about was when I actually received the paperwork. So first and foremost, how I knew about what was said in document, I had an attorney. I actually still have a letter at home. An attorney reached out to me from Michigan. I'm not from Michigan, I'm from Illinois. And I guess they was trying to get me to, I guess, retain them to represent me. So this is how I found out about this whole court case. Exhibit 1 and Exhibit 2, what I'm asking for when I got this in the mail, when I was calling Mr. Foley, was because I did want to still have an amicable discussion on how we can come to it, but I wanted to let him know this document, Exhibit 1, Exhibit 2, states under the penalty of perjury that this happened. Anybody that sees me, I've had the same hairstyle for maybe since 2011. I'm a 345-pound, 6'5" guy. I'm described as possibly being 6 foot.
Yeah, Wixom, you're good. I didn't take any malicious intent behind your question. It's all good. And that is a great way to find out you have court. I didn't really think about that. I mean, you get letters in the mail. Are they still considered ambulance chasers? The attorneys that, you know, if your name is on the docket for a civil matter and you all of a sudden get letters in the mail. I mean, it's happened to me. But I mean, I've gotten the paperwork for it. But yeah, weird. Phil, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Thank you so much, Phil. That's 10 tonight. Thank you, Phil.
0 from with a mustache to 240. Also, what I wanted time was because what I did was I was calling T-Mobile. Also, I was going to call Walmart in Richmond Park. Also, I do have a text message as well from my family on that night that proves that I was not at home.
But you did receive you're aware of these proceedings, right? And you know what's going on, right?
What I received was just, like I said, from an attorney that was trying to advise me, but they wanted me to retain him. I didn't have the money to retain that attorney. And my only question, Your Honor, is it really okay for someone to file Exhibit 1 and Exhibit 2 that they spoke to me personally under penalty of perjury, and this never happened? Like that, from what I'm looking at, that is illegal. I mean, unless I'm wrong about that. And that's when I was my point when I called Mr. Foley was I didn't even want to have a conversation about this in court. I was going to talk to him directly. Like, look, I have proof. I was not even home. I'm never home Monday and Wednesdays anyway, until late. And so, like I said, if I have the time, I'll get T-Mobile records and Walmart footage because I actually have proof and text messages I was not at home on this night.
You know what, Mr. Foley, I'm gonna grant you alternate service. You can mail this to him regular mail, and the notice of the default judgment hearing will set this out. We'll get you another hearing date, so you
Your
can,
Honor,
and I'll grant you alternate service.
if I may, I don't want to look Your Honor's generosity gift horse in the mouth, but if I may make one point, the process server company that we used, we had to hire an Illinois process server company. They are arm's length from us. I mean, we have no connection to them. We've used them in other cases. We've served all over the country. They have no reason to lie or make this up. on behalf of us, and there's a detailed service affidavit that they went to the door, saw this gentleman. What he's referring to as Exhibit 1 and 2 isn't our affidavit. It's the affidavit of the process server company that we filed. And just a tidbit of the messages that my clients received. Let me see here. Documents, text messages. I understand you are upset and angry.
I can't see that, Mr. Jones.
I mean, Your Honor, the text messages, he acknowledges the complaint. He says the claims in your complaint are stretching, you know.
Okay,
you
what was
need
the
to call
date
it
of
fraud?
Mr. Foley? What was the date of this?
December 10th is the date that my client's.
Yeah, I would be a little frustrated right now too. He just got accused of fraud on the court. Yeah, he's gonna respond to that. So I don't blame him for being a little frustrated here at all.
Screenshotted it and sent it to me. So it was sometime either on December 10th or just before that date.
Okay, and what day was the service effectuated?
Let me go back to the proofs of service. I just had them open.
So Your Honor, it states here that his process services served me at 7:01 on December 3rd. Now, Exhibit 2, he served me or tried to serve me again at 7:06. I have, and I don't know how I can screenshot or text it or whatever. I have a screenshot for me even speaking to my wife, at 6:47, because I'm calling home because I'm shopping. And then on the same day at 9:16, my wife's telling me, hurry home, I can't wait to snuggle with you. Like, I'm not even home. Also, I remember where I was. And for me, I'm willing to definitely have this conversation to get to a resolution. But I also feel if we are signing documents under penalty of perjury, then this should not be allowed to happen with someone fraudulently making claims that never happened.
That's what I said, Mr. Foley, so that we can not have to deal with this. I don't have to have a hearing on this, which I don't want to. I will give you the right to do alternate service by U.S. regular mail. So, Mr. June, you're aware that you're here, so you're aware of it. So the only thing I'm going to do is have Mr. Foley send it regular mail, and that's it.
Just so you know, Your Honor, the reason why I'm here is because his office sent me the motion via regular mail. So
Which you received.
But what I'm saying in terms of you got that, but wait, the motion, what did you have attached to the motion, Mr. Foley?
Unfortunately, I don't think a copy of the full complaint, but let me look.
I have the motion here.
Hold on, Mr.
I apologize.
Your Honor, attached to the motion was not a copy of the full complaint, but the following exhibits. Exhibit 1 was the proof of service on him personally for his person. Exhibit 2 was the proof of service on him as the agent for RMG Logistics. Exhibit 3 was the default request and entry, which had already been served before, but we reattached to this as an exhibit and thus served him with it. Exhibit 4 was the default judgment that we're requesting as detailed, and no response to that motion has been filed with, Your Honor.
Okay, so when you served him with a copy of today's motion.
You're absolutely right. You're absolutely right. I do talk a lot. I talk a lot in my live streams. I like talking to the chat. I like talking to people who don't like me talking. It makes it a lot of fun. It really does. Thank you so much. And because of that, I will do an early pause. You know, can't troll me, bud. Another squid. Thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members, followed by Alan with 5 more gifted memberships. Thank you. 10 new members. Welcome and thank you both.
The default judgment and the notice of hearing because he's here, correct?
Yes. And Your Honor, may I ask the defendant one question?
Yes, you can ask me and I'll ask him.
Just whether or not he has actually seen the complaint in this case, because he too is under oath.
Have you seen the complaint in this case, Mr. Juden?
I have only via this paper, and I've talked to the attorney about it. The attorney that tried to represent me in this case, but I didn't have.
Did he send you a copy of the complaint?
Say again?
Did he send you a copy of the complaint?
I haven't got the complaint personally, but do I know? I'm not gonna lie. Okay. I didn't know about it. I know about it, but did I get it? No.
So, Mr. Fuller, as I indicated, what I'd like you to do is to serve Mr. Juden by regular mail
Yes.
a copy of the complaint. And then we're gonna have to renotice this. So you have to send them a renotice of hearing. And that's gonna be for April the 3rd, 9:45 via Zoom.
Is that the only available day, Your Honor?
Yeah, my April and May are crazy.
Reason
Why?
why,
I was saying why?
Oh, well, because the April 2nd to that Monday, I'll be on a cruise, and so I
Okay.
didn't know.
Okay, hold on. 17th, April
April?
17th. Yeah.
Understood.
April 7th. So, Mr. Foley, please, as I said, the court is giving you relief to serve Mr. Juden by regular mail. And so we need you to serve because he has the default judgment and the motion for today. Serve him with the complaint and the renotice of hearing for April the 17th at 9:45 via Zoom.
Will the same information be the same on today's?
Pardon me? Yes, it's the same Zoom information, yes. Is that what you're referring to, sir?
Yes, ma'am.
Yes, yes.
And one last thing, Your Honor, is it the unlikelihood of having the opportunity to try to work this out, or it's just that they just don't want to talk, they just want to go through the court? Like, what is that?
Mr. Foley, is there room for a conversation?
There is, if that conversation doesn't include substantial alteration of my client's rights. We have attempted for a year to have that conversation. Unfortunately, what we were met with, without disclosing details, was very not acceptable.
Okay.
I will always engage in settlement, Your Honor. We always want to, but at this point, my clients are understandably frustrated, having waited 2 years and received no money. So
Your
I will
Honor,
renotice as the court has instructed me. I will also open a line of communication with Mr. Juden, and if something can be put in place, then I
Prior
would
to the
rather do that,
17th?
of course.
Okay, so if it's
all I
resolved prior
want,
to,
I'm not getting any communication from this attorney on this, so it's like I'm not getting no communication from them whatsoever right now. And so for me to even try to resolve this, it's like I feel like it's like skip
Well,
me because I'm not getting it from nobody.
as Mr. Foley has indicated, the lines of communication are open, but just not to the extent that they have previously transpired. If not, then we'll see you on the 17th and the court will deal with the motion for default judgment.
All right, thank you.
Okay, thank you, Mr. Foley. I'll look for that to be renoticed.
Thank you, Your Honor. I will file
And,
a proof of service by alternate service regarding an order for today. May I submit that directly to the court?
E-file,
E-file.
yes, E-file, indicating the adjourned date today. Ms. Clifton says today, that the alternate service, U.S. mail, served the complaint. The matter has been adjourned to April 17th, 9:45 via Zoom.
Perfect.
Okay,
Your Honor,
thank
am
you.
I allowed to even file a complaint and with the false Exhibit 1, Exhibit 2, not against Mr. Foley, but his process server? Am I allowed to file a complaint?
No, because I'm not gonna, that's why I'm having him reserve it.
Okay.
That's why I'm having him reserve it. So we don't even have to, because I don't want to have a hearing on that. That's why I told him to reserve it, so I don't have to go down that road. That's a avenue that I don't even have the bandwidth to have in over 1,000 cases, so no. Thank
I
you,
appreciate
but we'll see.
Thank you, Your Honor.
Thank you.
All right.
April 17th, thank you.
Thank you.
All right. Negotiation should be fun with that one. Hey, I'm about to go on vacation, and I know I owe you a bunch of money. Oh, he's gonna be like, oh, I can give you $50 a month. Like, no, you're going on a cruise. You can give us $250 a month. All right. This is why you don't talk like that in court, dude. Just say you're busy or you can't make it. You don't have to say you're going on vacation. Or say you're going camping. Say something. Just don't say a cruise. Like, I mean, I guess it could be worse. I think I keep getting hit up with cruise specials, or I keep seeing advertisements for them. Like, man, is no one going on cruises anymore? They're crazy inexpensive right now. I'm not gonna do it. No, I've done that once in my life, and that's all I need. I don't need another cruise. Sassy, thank you so much for the super chat. Interrupter, yep, that's me. That is me. I am known for it. Germager, please talk more in honor of is it KIB or KLB? I don't know. Anyways, Yeah, I get those messages all the time, and usually when I see it in a live chat, I always make a comment on it. But here's the thing, right? This live stream has been going on for an hour. We are at almost exactly the 50-minute mark. So I have been talking for 10 minutes out of an hour, and we've watched 50 minutes of video, and that includes the 3 or 4 minute intro and the pausing in between clips like I'm doing right now. So realistically, I have only paused it for about 2 or 3 minutes in while a clip is playing. So if that is too much, then yeah, I can't make it any less. I can't, not unless I want to get in trouble with YouTube. Anyways, let's go on. We're moving on to the last clip of the evening. This one's a little different. We're jumping to Judge Perkins' court. Yeah, that's all I'm going to say. Let's go.
Okay. Let's go back on the record with Mr. Gibson. Mr. Gibson, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
MB, 27 months. Dang, you top Phil. You top Phil. Thank you so much, MB. You are one of the OGs. Well, so is Phil, but I was amazed when Phil's came out. I think his was at 26 months earlier. You got 27? Man, I need to see what Heather's at. She was the very first member. Should be, well, because she became a member before I even made it known that I was monetized. So yeah, she cheated on that one. But anyways, MB, thank you so much.
Your Honor, my client would take advantage of the offer and enter a plea as charged.
Is that what you want to do, Mr. Gibson?
Yes, sir.
Can you raise your right hand, please? Do you swear or affirm, tell the truth, whole truth, nothing but the truth?
Yes, sir.
Put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, sir.
You understand that you have an absolute right to a trial?
Yes, sir.
Mr. Berry, one.
Oh, absolutely, Larry. If you guys don't like chatting, Members Monday is not for you. It's fun. I open the panel. There's a bunch of us on panel. We're all discussing the case. We get off topic every once in a while, or a lot of the time, but it's still a lot of fun.
Over your other advice or rights in the breakout room, did he not?
Yes, sir.
You understood those rights?
Yes, sir.
You have any questions about those rights?
Yes, sir. No, sir.
What kind of, you don't have any questions about those rights?
Yes, sir. No, sir. No, sir.
Who's talking to you? Who's in the background?
Nobody, sir.
Okay, now I'm not gonna sit here and listen to that, because that's clearly a lie. Who's in the background?
I understand everything you're saying, sir.
Who's in the background?
Answer the question. I just walked in the house, sir.
What is your name, please? Good morning to you.
Good morning, sir. My name is Cleveland Dominic, sir.
Okay, Mr. Dominic, this is not your case. This is Mr. Gibson's case. I need to know and make sure that Mr. Gibson knows and understands his rights. You cannot assist him on answering any of the questions, okay?
I understand, sir, Your Honor.
All right. I'm gonna go back and ask you again, Mr. Gibson, do you understand? Did you understand your rights that Mr. Berry went over with you?
Yes, sir.
Do you have any questions about those rights?
No, sir.
You know, by taking the deal, you're gonna give those rights up?
Yes, sir.
Do you understand what's going on, sir?
I understand. I want to pay the $500 fine.
I mean, do you understand what this, what my line of questioning is about?
It's about me firing the firearm.
No. Mr. Dominic?
Yes, sir.
How are you related to Mr. Gibson?
He's my brother-in-law. He's my wife's brother, sir.
Okay. Does he have any issues with understanding and comprehension?
He's not per se. Certain things, that's what I'm trying to, he was talking fast, he's not going to catch it. That's why I was trying, he understands what's going on here, you know, so that's why I was trying to assist. I didn't mean no disrespect at all to the court, sir.
Not taking it as any disrespect at all. All right. So, Mr. Gibson, you have certain enumerated rights. You have certain rights, okay? One of those
Yes,
rights,
sir.
I say, is you have a right to a trial. You understand that?
Yes, sir.
So you don't have to take this deal if you don't want to. You have the right to remain silent.
Okay.
And it's on the people to prove you guilty beyond a reasonable doubt. You don't have to say anything. You don't have any burden. Do you understand that?
Yes, sir.
All right. So you have a right to call witnesses on your behalf.
Okay.
And again, you don't have to prove anything. Now, if you want to take this deal, it's going to require you to tell us what you did. You understand that?
Yes, sir.
And if you take this deal, you're going to be giving up those rights to the trial and the right to remain silent and the right to call witnesses. You understand that?
Yes.
And are you prepared to give those rights up now and take this deal? Or do you want me to set a trial date? I can assign you a lawyer that can explain things more comprehensive if you need it.
No.
Do you think I need to assign him a lawyer, Mr. Dominic? At this point, it can't get any worse. It can only get better or stay the same.
Yeah. Well, no, because he did say he fired the firearm.
I didn't ask him what he said. It's not about what he said.
Right.
You understand that?
Yes, sir.
I'm going to sign him. I'm going to assign him a lawyer, Mr. Berry. I'm going to assign him a lawyer. That way, you can talk to the lawyer and and get advised, and they can have somebody specific to you, and they can spend a little bit more time with the case. You understand that?
Yes, sir.
All right. Because I still don't think you're really comprehending everything I'm trying to say to you. Okay.
Yes,
I do need a good phone number from you.
Y'all know about her?
Hold on, y'all. I have to look my number up.
All right, take your time.
It's 313.
Oh, look at that. I actually remember to edit this out. Yeah. All the editing tips you guys have been sending me, they've been working.
Okay, I'm going to appoint you an attorney. What I need you to do is answer the calls you don't recognize. One of those calls should be that appointed attorney. If you don't hear from that appointed attorney by your next court date, which is going to be March the 24th, 2026 at 8:30, then we'll get one appointed to you on the spot on that date, okay?
Yes, sir.
All right. If there's nothing further, Mr. Gibson and Mr. Dominic, I wish you guys have a very good rest of your day, and you're free to leave. Best of luck to you both.
Thank you, sir.
All right. All right. That's it. That's the show tonight, guys. Real quick. Wixom, I'm not going to bring your super chat up because I don't know why you're intentionally trying to antagonize somebody. I'm not about to strangle you, but if you get timed out, don't you're asking for it, so just don't take it personally if you do. That's all I'm going to say to that. But I do appreciate the super chat. All right, everybody, thank you so much for watching. I do appreciate it. You guys are all awesome. Thank you so much for the super chats, the gifted memberships, the membership milestones, and mods. You guys are awesome as always. Thank you so much for your hard work. Who are we going to raid? I'm going to look to see who's available. I'm going to go back to the chat, and it's going to be like everyone's going to be saying something. All right, what we got? KFAR, Lone Wolf, and Katie Z. Where are we going? Where are we going? First one I see that's not a mod. Mods can't vote. First one I see. All right. Well, my headphones just decided to stop working for a second. I don't know if you guys heard anything. All right. You know what? We can rate KFAR. We haven't rated KFAR in a long, long time. We'll rate KFAR tonight. Oh, all right. Cool. Cool. Yeah. No. Yeah, I understand. I understand. Did I call you a troll or did I say you can't troll me? I doesn't. I'm sorry. I didn't mean. I didn't mean it to call you a troll. So this is my apology to you. So I do appreciate you hanging out, and please accept my apology. But yeah, I do talk a lot, especially during live streams. I talk as minimum as possible during my regular uploads, but I really do enjoy having conversations with the chat, interacting with the chat, and I think that's why a lot of the people enjoy coming to the channel is how much I interact with them. So I do try to do it at appropriate times. I do get carried away sometimes though. So anyways, please accept my apology for calling you a troll. All right, so let's go. We're gonna go to KFAR tonight. All right, got that set up. Go tell him I said hello. And yeah, I'm off tomorrow night as usual. Tomorrow night is date night, so I'll be hanging out with Heather. Then I'll see you guys Sunday night back at the regular time. Members Monday on Monday. There were a lot of gifted memberships tonight, so maybe we'll get some new faces on Members Monday. But yeah, I'll see you guys on Sunday night. Have a great weekend. Don't do anything dumb. You don't want to end up on my channel. I will cover you and I'll jump up and down and say I know you. So you don't want that. You don't. Anyways, have a great weekend. Go tell KFAR I said hello. Okay, bye.
You're welcome. All right.